Hey guys, welcome to another podcast with The Mortgage Man. I'm here with Holly from Succession Wills. Yes, got it right. And we're going to talk about why it's important to have a will, because unlike me, I do not actually have one, which is probably a bad thing because I'm telling this to have you here. But I think it's one of those things that a lot of people don't even think they should have unless, like for me, it was like when I had my first kid, I was like, oh, maybe I should have a will. Yeah. Which is probably the same thing when you buy a house, insurance, that kind of thing. And before we go into having a will, I want to know about your first home.
Yes.
Which, as I have realised now before we were talking about, is not probably a happy story. But I think I just deal with this with everyone. It's like it's good for other people that are watching / listening, like what was it like for you? And just gives people more confidence in like what the situation is. So did you buy that long ago?
So my first home is probably not such a happy story. That was resulted in, I can say this, 4.5 year long legal battle. My second home is probably a nicer story
let's
to
talk about
share.
that one.
Yeah, let's talk about that one.
Yeah.
That was great.
You still own it now?
I still own it now.
Yeah.
It was actually a great experience, to be fair. We worked with a broker.
That's good to hear.
Yes,
yeah.
Which made our life really easy, to be honest. We gave them the documents and they did everything for us. We found a section, worked out our deposit, used KiwiSaver, used our savings.
How long ago was it?
We put money down on the section in, what are we now? Maybe 2022, and it was in Wanaka, so it took 2 years to title. So that was where you put your, I think 5 or 10 or 20% deposit down on the section, and then you wait till title comes, and then you obviously settle then. We were quite lucky. We got our plans done during that waiting period, so the holding period, so that the minute title settled, we started, title issued and we settled, we started building like the next 2 days.
Okay.
And built with a company. They were amazing. They did it all, and we walked in when it was finished.
So do you wish you were renting again?
No.
I bring that up because I always see on social media, they're like, oh, housing is too expensive, I would rather rent forever. And I'm just like, I don't get it. I was like that when I was 24, and I was like, oh, you know what, housing is expensive, I would rather rent. But then I was like, hold on, rent's going to keep going up. Yeah. House prices, you kind of lock in your mortgage unless you borrow more money.
Yeah.
So it just makes it easier financially, I think. But also, like, you have a house, a home, and like you can have that security.
Yeah, and you can, if you're smart, you can do income. So we did a 3-bedroom, 2-bathroom, office, home, and an apartment, which
Wanaka,
is fully
fully
self-contained. You
Yeah.
can rent that out. 1-bedroom apartment you can rent out for $600 a week.
Okay.
That's a fair, decent.
Yeah, and we do have people that if you're going to build something, you may as well add that on. I think I'm doing one in the moment in Riverhead, and they're doing something, they're like building a nice ass house with a self-contained 2-bedroom place, which is just like rental income. Yeah. But you got to have the income, right, to be able to service it. And the way that you make your income is by doing wills for people. That was a really good segue.
It is.
So starting from the basics, because I think most people have heard of a will.
Yeah.
And probably don't have them. But what is a will? Like if you were to explain it to the most, like a 12-year-old.
Yep.
Maybe a 15.
Okay. So a will is literally the one document that deals with your entire life when you pass away. There is not another thing that is relevant when you pass away. The one thing that is relevant is your will, which is a document which dictates essentially what happens to everything in your life, including your kids and all your assets and your debts and everything. So it is the one document that essentially deals with your life after you're not here. So it's like your final instructions, your final message to your family for me, it's your final message to your family to be like, I've thought about this, I've done the work so you don't have to.
Yeah.
Because when you don't.
Yeah, what happens is they don't have it done.
So then we have the Administration Act. So there is laws in place that obviously can deal with it because we need something to say if you don't have something, what's going to happen. And then that becomes a process where you look in the order of priority, who's got priority to kind of step forward to do this. You're obviously working with a lawyer who's probably anywhere between $350, $500 plus GST an hour to start that process, and then you're trying to figure out who's got priority, does everyone agree, and then the default provisions apply. So and that depends on your circumstances. So there's like a tree you can look up, and it's like if you're single and you've got parents, your parents would be first in line. If you are in a relationship but your parents are still alive, it'll get split between your partner and your parents. So it doesn't, a lot of people
50-50?
No, it's 2/3, 1/3.
Okay.
And then the same like with kids, if you've got a partner and children, it doesn't all just go to your partner, it'll get split between your children and your partner, 2/3, 1/3, plus there's like a cash sum as well that goes to your partner in the first instance. But when you're looking at equity and property and things, like you can quickly, like that can become a substantial amount of money as well.
And not everybody has a good relationship with their parents or their kids
or their partner.
Ex-partner,
yeah.
whatever. So, yeah, it sounds like it could easily be complicated. So if you owned a property with somebody and it was owned in your joint names, does your share just automatically go to the person you own the property with?
Yes.
Okay.
But more often than not, I speak with people who say, no, I own it jointly. And I always said, I literally did this last week, and I was like, oh, can I just double check just to make sure? Because they're like, we don't have anything in our separate names. We own our property jointly. And I looked up the title and it was tenants in common. And I'm like, you absolutely need a will.
So what is the difference then in that scenario? Because a lot of people just buy it and
they probably don't even know what it's owned as. The lawyer did it and they're not sure. So joint tenants is where you own it jointly, and when one of you passes, it goes to the other by way of survivorship. So you don't need a will provided they survive you. Another caveat there, a lot of people go, oh, my partner will inherit it. In a car accident. Okay.
This is a depressing situation.
Yeah, I know.
Why are we talking about this?
Sorry.
It's like insurance.
Yeah. So joint tenants, it does go to the other person by way of survivorship, provided they obviously survive you. Tenants in common means it doesn't automatically pass to them. It goes per your will, per your instructions, or if you don't have a will, it's going to go per the Administration Act. So if you did want it to go to your partner, but your parents were still alive, it's not just going to go to your partner when you own it that way.
Which would make a bit of a difference if you owned the property with like a brother or a sibling or a friend and had a partner and had a family. Yeah. Okay. Cool. So I feel like when you have kids, people start thinking about wills. And that usually happens after you buy a house.
Yeah.
So does a first home buyer, because obviously most of my audience are first home buyers, does a first home buyer need to have a will before they buy, after they buy? What would you say, I guess, is like the first time somebody should actually start thinking about a will? Because I've seen on one of your videos, you're like, if you've got $15,000 in KiwiSaver, you need a will.
Yeah.
To me, $15,000 is like, if I die, $15,000, who cares?
Yeah.
But like, that is a lot of money for other people.
Yeah.
And is that just like your opinion, or is that like somebody's actually like written that down as an official good piece of advice? Or is that just a hook on a TikTok?
No.
That's like...
So that was our legislation up until September, I think it changed. So up until September this year, the threshold for being able to access anybody's assets after they passed away was $15,000. So if the assets exceed $15,000. So if you had $15,000 in your KiwiSaver and you passed away, your provider can't release it unless your will says who it's going to, and if you didn't have a will, you'd have to go through the Act. So you think $15,000 may not be a lot, but as soon as you're getting a lawyer involved to draft that letters of administration application we talked about earlier, that's chewing a lot into if it is $15,000, where if you paid whatever for a will, even if it was $1,000 for a will, your application's going to be a lot more straightforward to get that released. But it was a good hook, but the government have, as of the 1st of September, raised that to $40,000. Okay. So it's still, I think, like a sum of money where you can have that in KiwiSaver and, not maybe be thinking about it much, or you might have it sitting in your bank account because you are saving to buy your first home and that's going towards your deposit. Or you've obviously bought a property and now you've got equity in it. If you own a property, you absolutely need a will, full stop. But
if you have kids. I feel like, kids, own a property and have kids.
Yeah, or $40,000.
In KiwiSaver.
I'd even say less than that, because I'm like, if you're in a position where you can do it now, it's in place for when your assets grow. It's not like when they grow, it all of a sudden becomes null and void. So it could be something that you might go, I'm on the cusp, got 20, 30 grand sitting there. Maybe I'll just do it now and then it's in place and I don't have to think about it for a long time. Or at least once you're close to that 40 grand, I'm like, do it, it's in place. It lasts when you buy, sell, change your assets. You don't need to update it all the time. I personally think you should do them in 3 phases in life. Like, maybe you're single, maybe not, but like kind of single, you've got your assets, and you know, you might want to look after your siblings, your parents, your friends, whoever, then you're in a relationship and you're kind of getting serious and you're thinking about starting a family. If you have done it pre-family or pre-wedding, a wedding cancels your will. Another random fact in there. A lot of people don't realise.
Wedding cancelled. Okay. So, assuming that your will
is valid.
But let's say you were single before you're married. I guess what I'm thinking is, where does relationship property law come into this?
Okay.
The will supersedes. I mean, they're dead, so does relationship property law go into it at all?
So relationship property law is relevant as soon as you've been together with somebody for 3 years.
Yeah.
So in de facto, that's going to come into play. If you're under 3 years, you don't need to panic about it. But even if you had a will leaving everything to your partner that you subsequently married, it doesn't matter. It's the one thing that cancels a will in New Zealand is by virtue of getting married. So even if you put your will in place with that partner, you got married, your will is now cancelled, and relationship property laws apply for separation, and you can claim, division and passing as well. So that could be an argument if you're going under the Act and it's getting split between the partner and the parents, but best situation would be to just update it.
Yeah, so if the will gets cancelled by marriage, then what happens to your assets when you die?
It goes to the default provisions under the Act. So again, split between partner parents or partner kids, depending on what your dynamic is.
Okay, and then so if you technically don't get divorced, you're separated and you don't get divorced, where's that?
Your will still applies, yeah.
Oh, that's not good. That's not good.
Well, it's happened, and it happens, because a lot of people, I've had clients who have separated and don't divorce, but also in New Zealand you can't divorce for 2 years until you've been separated. So it's not like you can say, well, we've separated and they're not going to get anything. If you haven't changed your will or you don't have a will, they're technically your spouse and they're going to be the default beneficiary. Yes, you can go fight it, but I'm like, you're looking at tens of thousands of dollars plus to fight things like that. Like, it's not a couple of grand here or there.
But if it's $2 million worth of property, people get pretty crazy.
Yeah. And you're going to spend thousands and thousands, tens of thousands, maybe even hundreds of thousands if you're looking at a couple $1 million property, depending on what the arguments are there.
Okay.
But no, so separating doesn't cancel a will, and it doesn't. If you weren't married, separating would be fine. If you're married but you've separated and not divorced, that's where your relationship property laws are going to still be in place. Or if you had a will leaving it to them, it's still valid. It doesn't cancel it.
So, just so I understand correctly.
Yeah. Say it back to me.
Yeah. So you get married to someone.
Yeah.
And you have kids from a previous marriage, and you want your assets to go to your kids because maybe you just love them more. That doesn't matter because you're marrying this new person. They're more likely going to get your assets because that's the order of administration, or like it goes to 2/3, 1/3.
It's going to do the 2/3, 1/3. And also relationship property laws are going to apply, so they can opt for, if you pass away, they can opt for a 50-50 division of the relationship property pool. So if you are wanting to protect your assets and leave them to your kids from your previous relationship and not look after your spouse, you 100% need a contracting out agreement, which is commonly known as a prenup.
Interesting.
Which is also normal. I feel like we need to normalise the conversation around prenups.
I mean, I wish I had one.
I think a lot of people do.
Okay, so I can see why this does get quite complicated and messy, I suppose, when people start thinking they're going to get money. Because you always see in the movies, like, I was going to get this and now I'm going to kill you. So I guess to summarise, you should get a will if you've got more than $40,000 worth of assets. Having kids, getting married. Getting married kind of cancels it, but then if you're going to get divorced, you need to put it back in place.
So, if it got cancelled and you never redid them, you should absolutely do them on separation. I think
it's so complicated. You probably need a lawyer to help you with this.
You need somebody who understands it all and can understand that whole picture.
So, just going back to this situation, because I feel like, when you have mixed families, new wife, like you want your assets to go to your kids because they've probably been in your life for like 18 years and maybe your original spouse died. How do you protect your assets from money hungry people? Like say you're like later in life, you're 50 years old, you get married because you just want companionship, but you still want your assets to go to your kids regardless of if you're married or not. like, how do you protect that? And I had a question on my phone. This is a good way of getting it.
Okay.
Is that how, like, trusts get set up to kind of make sure that the property owned by the trust gets paid out to the beneficiaries, which would be the kids as opposed to the new wife?
Okay.
Is that kind of...
It's one structure,
Yeah.
but it's also not foolproof.
Yeah.
For me, like, if you really do want to protect them, you have the conversation about getting a prenup. Like, to me, that is the foolproof way, and people go, they can be challenged. If they're done well, like, they will stand the test of time. So I'm like, they're not actually that easily challenged. Like, if they're done properly and done well, they will stand the test of time. Trusts are good if you set it up if you set it up once you've met your partner. There's no point in having a trust. There's going to be a claim that's going to be considered relationship property. If it was set up, let's say it was that situation where your spouse died, and you set it up then and there, and you didn't know whoever you were going to meet 10 years later, and it's owned in the trust, and that's your structure, great. That is going to serve its purpose. It can, again, my recommendation would always be, in addition, have your prenup, just to clarify, because sometimes people aren't super clear on what's the trust and what's mine, and there can be a bit of mixing and mingling and maybe not documenting things correctly, and you should, but that can happen. So I'm always like, trust can serve a purpose if it was set up prior to the relationship, then great, that is one asset structure, because you don't own it personally, it can't be relationship property. And also on the flip side, like, if you don't want your kids to have it and it is in a trust, there's potential, they can challenge your will under the FPA, but they may not necessarily be able to challenge your trust. But anyway, back to that first one. So yes, trust can be serve a purpose if it's set up prior to the relationship. If you're in the relationship, have the conversation. And I think, if somebody's not there for those reasons, and prenups aren't to say that you get nothing and it's this really hard, what's mine is mine and what's yours is yours, and that's the fault. Like, they are so fluid. You draft them to whatever your dynamic is, and if somebody's not willing to sign, then you make a decision whether you want to continue that relationship or not, because that is the question. It's saying, but for this document, I would have ended that relationship, but this document gave me the certainty to proceed because I knew my assets were protected.
It's a good way of testing the water.
When I was practicing, I had clients who brought up the conversation, they wouldn't sign, they walked away.
I mean, it is a good make or break, can't draw the line in the sand kind of thing.
Yeah, but also have that conversation early. Don't do it once you're actually qualified under the Act. Do it before
marriage.
Well, do it, I always say, you're 2.5 years in. Have that conversation. Because if you're good at 2.5 years and you think you're going to keep going, it could take 6 months before you've got that all sorted out and signed. But yeah, once you're over that threshold, the motive for somebody to sign. I feel like you should do prenups, wills, and
EPAs. So obviously you do EPAs as well. So where does that come into it? What does it stand for?
Okay.
And
So EPAs are enduring powers of attorney, and a great document, very different from a will. A will is an amazing document, and everyone needs one because unfortunately we all die. That is the reality of life. And you need that when you die. An enduring power of attorney is relevant if you are alive but lose capacity. And that could be for a various range of reasons. So commonly people probably associate it with people with Alzheimer's or dementia. So they're alive, they're living, like you can be going to get your nails done, if out supermarket shopping.
I probably won't be getting my nails done, but yeah.
Or you could be going to the hairdressers.
Hairdressing. These are bad examples.
Yeah. Playing golf, you can be out living your life, but you don't have that mental capacity anymore to manage your money, make those decisions and things like that. So they come in and somebody sort of does all that for you. But I have had clients in my time with people in their 40s and they have a stroke, and they may make a full recovery, they may not, but there can be a year or two where they're learning how to walk again, talk again, all those type of things. And in that time, somebody still has to pay your mortgage. Somebody still has to pay your rates. Somebody still has to pay your power bill, your grocery bill, your medical bills. Somebody needs to decide what treatment you're going to receive, or people at a work site, or even just walking down the street, knocked on the head.
Yeah.
So
obviously you get insurance to help out with that stuff, but that doesn't help you make decisions.
No,
you have
so
to have somebody to do that.
So all great if you've got insurance and things in place, meaning you don't have to go to work and somebody can look after you, but you need somebody in charge to manage that money. And if you don't put an EPA in place, the only way around it is going to the court to get appointed, which again takes time, costs money, and who are we appointing?
Who do they, by default, who do they usually appoint? Because you'd assume it'd be the person that has the closest relationship with that person, right?
Yeah, so I think couples tend to appoint each other. It's quite rare where they don't.
What if the court appoints one? Is it the same? They just appoint the
An
person.
order of priority. So,
Yeah.
and then it'll make a case if you're the most appropriate person, and if people don't agree, then it's gonna, everyone's gonna have to submit their case, and somebody's gonna have, if you've got siblings, like it could be like for a parent,
Yeah.
you might have siblings who don't like each other. So then that gets messy and complicated, and there's provisions within the document to like account for your siblings, if you've got children and you're just picking one, to say, well, they're in charge but they need to keep these people informed, because we actually do have a lot of elder abuse and property abuse in New Zealand. So there's quite a strict criteria when it comes to EPAs and how you put them in place and getting them certified and things like that, to make sure somebody isn't forcing mum to put them in charge of her money and then draining her bank account, and all of a sudden there's nothing left when she passes away.
Yeah, so if you have an EPA set up, can that person then have the power to write a will on their behalf or appoint people on their behalf, and therefore put themselves as the main beneficiary of such will?
It's a really good question. So we actually
Just
have
trying to figure out how I get in there, over my brother.
Push him to the side.
Yeah.
So we actually have to ask that question in the EPA document. We say, do you want to permit your attorney to make a will on your behalf? I always advise people no, purely for the fact that we made a will where they had capacity, and why would we want that to change?
Yeah, because you're usually going to do those two things at the same time,
yes,
right?
Correct.
So maybe if there wasn't a will in place and for some reason they just did the EPA
Yeah.
and not the will, then maybe
They
have that
might,
power.
yeah.
Okay.
And the court might grant somebody that power if they didn't have a will and they've been court appointed, because again, it's going to make the process a lot easier to deal with after somebody passes away if they've got a will versus not. But yeah, so appointing each other if you own a property together as well, making sure that's important. So like we talked about the friends or siblings going to own a property together, and it's like, cool, one of you loses capacity. You can't do anything with your property. You need both people to sign off on your mortgage rates, on your...
Not just if you're going to sell it, right? Because
Yeah.
usually that's what would happen, is you
Yeah.
sell the property.
And you can't just sell, you can't just, my brother could sort it out. You're legally on that title. Somebody has to sign for you. They can't just do that. It's not just something somebody can go, oh, well, I'm the co-owner, I'll just do it. Or I'm their wife, or I'm their husband, or I'm their child. Of course I can. Like, it doesn't work like that. So a lot of people assume, and we're assuming wrong.
Man, I feel like being an adult just is going to become so much more complicated when people start dying around you.
Yeah, I think it's the wake-up call. You don't know what you don't know, and I think that's part of my big thing, and that's why I started doing the videos and things, to educate people, because even like we talked about relationship property, you don't know what you don't know. And until you're made aware, or, you go, oh, okay, that actually applies to me. Some people might be fortunate enough to be in families where these are conversations that they have, but there is a lot of people that don't talk about this in amongst their family, or have, or have exposure to that type of conversation.
Yeah, I think it definitely is worth a conversation. I think, I know that my parents got stuff set up.
Yeah.
But, they're not like, Aaron, you've got a kid now. You should
You should do it.
Yeah, I should probably know better.
Yeah.
So if somebody wants to set up a will, is there, best practices? The reason I bring this up, because I remember when my granddad died, I think, he had something set up where it was a public trust, and it was, really cheap to set up back in the day, and the executors of the will were going to take 3% of his assets. And I was like, luckily in that case it was very little. So my parents were like, I don't really care.
Yeah.
But if 3% of a couple of mil sounds really expensive compared to if you're just booking a lawyer for a couple of hours. So is there best practices? Because I know that you're pretty transparent with your fees online. Is that the standard, or is there other places?
Fees vary tremendously when it comes to this. I always laugh when people go, it's free or it's a couple $100s, and I'm like, nothing's free. Surely we've learned that lesson in life now. Everyone knows that nothing's actually free. There's always catch.
So that would be the example of they just take more later on.
Yeah.
Right. So I was like,
So
we'll
they've got
do
an
it for
interest,
free.
yeah.
And then later on we're going to sting you with 10% of the actual amount.
Yeah.
Okay.
Yeah, so I really disagree with practices like that, or, and people think, we need to be on there as executors. No, you don't. So, there is a place for professional executors, trustees on wills, especially when it's complicated family and it might be a lot of money and we've got blended family structures and we're wanting to look after new partner and kids and all that type of thing. And sometimes in that case you might go, actually a professional's best suited to do all of this to make sure it's done right, there's no emotion involved, and they are independent. It gets really messy when you've got like the wife as the trustee or the new wife as the trustee and also the beneficiary, and you know, what hat are you actually wearing? Are you sitting here as the beneficiary going, I want, or are you sitting there as the executive trustee thinking about all parties involved? But I think, what's the right word? I'm trying to say
best practices.
Yeah, best practices, and being being honest about, you know, is it actually free, or because we, you know, you also have these like will books and WITCLs that you can buy and you can do it yourself. And my biggest thing is you don't know what you don't know, and you don't know you have a bad will until you die.
Well,
So
you never
you don't know. So
someone else knows. Yeah.
Somebody else is going to know you had a
Yeah,
bad will.
yeah.
You'll never know because you don't know until it's too late. And I think, like, so my pricing is very transparent. So for an individual, it is $650. That, you know, it's not plus GST, office expenses, disbursements. It's not here's extra time if you're more complicated or extra hours and all those type of things. That is the price. That is the price. I have no interest at the other end. We do it once. It's done. If it's couples, it's slightly cheaper. But yeah, when I look at that kind of pricing, or somebody might say to me, oh, that's expensive, I'm like, do you know how much a lawyer charges?
I feel like that's not that expensive.
No, well, that's actually true. I get a mix of reviews.
I feel like sometimes I commented on one thing, I was like, you should put your prices up.
Yeah. I think everybody in Auckland has said that to me.
Yeah.
I had an accountant ring me and he's like, do you know how much, like, I did this couple, they had a trust and we did all their stuff, and he's like, do you know how much, like, their stuff is worth? And I was like, because I knew they had various properties and things, but I don't know the values of them because I don't need to know the values when I'm doing. Anyway, and they were like, it's like well over 10 mil. And he's like, you should have charged about 10 times what you charged for that.
Should we edit that price out? So it's actually this.
Yeah.
Yeah. Okay. So if you charge that, because obviously you also need to help at the back end, right?
So I don't help.
Okay,
so I'm purely in the
setting up.
Let's do it right and make the back end smooth. Because also that's another thing, you know, a lot of people don't realise, and some people might go, oh, don't worry, you can deal with that later. But I'm like, dealing with that later is $350 an hour, like, you know, $80 per 6 minutes that you're going to get charged for fixing those little things that you think, yes, they're fixable, but again, they're going to add a couple of grand easily to the administration side of things, even if you've got a will because it wasn't done quite right. You know, names not correctly, maybe putting in locations, and there's certain things you can do that can definitely save costs at the other end, which is what I'm about. I'm trying to set people up so that they have a really smooth process at the other end, not... I'm
going to ask you a hard question.
Okay. Hit me.
How many people have actually died that you've done wills for? And because that's obviously a true testament of how good your will that you wrote actually was, right?
Yeah.
Because you can be like, yeah, this is all good in practice.
Yeah.
But then when it gets to the other end, you're like, oh, Holly did their will. That was like, did it work? Like that's because I assume there's not that many people that have died yet.
No, there's been a few, but I think for me as well, when you're dealing with it, you see what other people have done. So that also teaches you. So despite maybe I hadn't drafted the will, but when I was practicing and doing estates, I saw what was involved and saw the mistakes that then you had to rectify. So I've learnt, fortunately, from other people's mistakes that I go, okay, well, I know not to do that.
And there's probably like you just have to factor in, I'm going to tick off all these things.
Yeah.
Right? And as long as you've done that, then you've done that.
Yeah.
Yeah. It's like doing a mortgage.
Yeah.
Tick off all the things, and yes, sometimes it's different, but it's still the proof of income, proof deposit, debt, blah, blah, blah.
You tick your boxes and you go through,
Okay. Yeah. Cool. Yeah, no, that wasn't that hard of a question. So I guess, is there anything else that people need to know about this kind of thing?
I think a lot of people think it's really overwhelming, particularly first home buyers. So I was practicing for quite a few years, dealing with a lot of first home buyers, and I've been a first home buyer. I get it. Like I think you and I, you know, you can become a little bit naive to, I mean, I don't think you or I are. We understand how people view it, but when you don't deal with this every day, it's really overwhelming buying a house. You know, it's a really big thing. It's something that you've been looking into, working towards. And there's a lot, you know, you're working with your advisor, you're sorting your insurances, you're working with your lawyer, you know, you might look at more than one property, like there's a lot. And I found first home buyers, when I was working with them, found it really overwhelming to try and deal with their will at the same time. Like people, and even actually people in separations, I'm like, okay, well, we need to tidy up your will, you're separated. And people don't have the capacity. They're like, I just can't think of that right now. So I think it's really normal, like you say, to people to not have a will and to not want to deal with it in that moment, despite, best practice saying you should. And that's like, it's to be like, that's okay, but don't put it off forever. Set a reminder in 6 months' time and revisit it. And I think for me as well, and why I started Succession was to take away the barriers, because I feel like a lot of people go, I don't even know where to start. Like, yeah, okay, I need one, but where do I even start? What do I need to do? And who do I speak to? And, lawyers can be intimidating with hourly rates, and, you have no, some people do give fixed prices, some people don't. But you don't know what you're in for, so people don't like the uncertainty. Having to take time off to go to work and things like that was another thing. Where do I fit it into my day? We're, we might be parents, we're working full time, we've got kids things after school, we've got things in the weekends. Where do I fit it in? Am I actually taking time off work to do this? And driving and all those kind of things.
I think the internet now.
Yeah, and that was my whole thing. Can
you do them online? You don't need to I guess you can witness.
I don't. Yeah, so anyone can witness wills. So you don't need anyone official to witness. So for your will to be valid, it obviously has to be printed on paper, and it needs to be signed with a physical pen, with 2 witnesses present. And the witnesses just can't be anybody in the document or in a relationship with somebody who's benefiting. So if you were leaving it to your children, you couldn't have your child's partner witness your will, but you could have your neighbours, you could have your work colleagues, you could have the people at the cafe next door.
Actually, there was someone in our antenatal group that hey, can you witness our will? Can you sign? I was like, okay. Yeah.
So a witness is pure. They don't need to know the content of it. They need to know they're a witness. They need to understand they're a witness to a will. They initial the pages, they sign. But it's also important, and I saw this situation, a person had done their will themselves and he was terminal and they did the wills process and it was wrong. Unfortunately.
How could it be wrong?
Well, so it's really a simple mistake. They put 2 different dates on the document. And you now have to file evidence to the court to prove what date it was signed. So something that started off cheap then cost 3-4 times as much as what it would have if you'd just done, or even my pricing, 4 times as much as that, because there was 2 different dates. So you can't just say, oh, well, it was this. Like, you have to draft your evidence, you have to file that, you have to get statements from your witnesses, and you now have to, you have to present that to the court to get the court to approve it, and then restart your process.
So if there is something incorrect on the will, but the people that are benefiting from the will are okay with what it says, do you still have to go through that process?
Yes.
Well, that's annoying.
Yeah.
The date's wrong. Okay, we don't care. Well,
no, tough buggies.
But the law cares.
The court cares.
Yeah, okay. So is there anyone that doesn't need a will? Obviously there's people that don't have any assets, so you probably don't need a will. But is there any other examples? So
I would say you don't need a will if you're under 18. So you need a will as soon as you're 18 or older. If you're under 18, you don't need a will. And then, once you've got an asset base of 40,000, so if you've got 40,000 in the bank, if you own a property, if you've got kids. But if you're
mega, mega, mega rich and you're just I don't care where my money goes.
Still have a will and care.
Because then you can be I wanted to go to this charity.
Yeah, and I honestly, people leave gifts to charity all the time. That is so common in New Zealand.
Yeah, I like that idea.
Yeah, lots of people have done that.
Probably better to do it when you're dying than when you're alive, on a way.
I've seen that happen a lot. I'm trying to think. Yeah, so if you don't need a will, if you're under 18, you've got less than $40,000.
So basically, everyone needs a will when they become an adult.
Yeah.
I have this question a lot. What happens to KiwiSaver when you die?
Yeah.
If you don't have a will, just that automatic?
Yeah. It becomes
people
part of your estate.
The government gets it.
Oh my God. But did you actually see the article? So the government can end up with it, but it goes through a lot of lines of succession before it ends up to the government.
Only if there's no one else in your life.
They can't track anyone down. So there was an article a couple of weeks ago, and it was almost 800,000 goes to the government because a man passed away, and he didn't have any lines of succession. So it happens, we laugh about it, but it can happen.
I'm pretty sure I was his nephew.
I had a client, and he's got probably in the past when I was practicing. He had probably like a $4 million worth of property, and he would be one of those people easily who wouldn't have a line of succession that you could trace. So if he didn't have a will, like that would have been...
Because you always hear about, like, I got some money from my estranged auntie.
Yeah.
And you're like, I didn't even know this person. Sometimes I'm the one that gets them a mortgage because, like, we got some money and I don't know where it came from.
We need to track that down.
AML. Yeah. So I guess the last question is, if you were to argue a will, what is the likelihood of it being successful? Like, if you like, is it worth going down that path if you disagree with what's on there, or is it just let that person's wishes be their wishes? I guess there's
from a personal perspective, I'm very much
so
my personal view is I don't think anyone should be entitled to anything. You know, I don't think your parents should have an obligation to leave you something. Like, why? Like, you're your own human, make your own life. Like, I'm personally of that view. Professionally, I would say go get legal advice based on the circumstances, because it is circumstantial every single time as to whether you have a chance or not. And nothing's guaranteed. I think a lot of people go, I've got a case. There is nothing guaranteed when it comes to courts in that sort of sense. You know, nobody can give you a black and white. It's like relation to property. Nobody can give you a black or white answer of what their outcome's actually going to look like. It's all very case by case. And in New Zealand, a lot get settled, so they don't all go through the courts as well. So there's not a lot of, cases that are going through every time you might see a challenge, because people do settle them between lawyers and things privately, and so the public isn't.
Okay.
So it really does depend. Like, if you do feel like you've been hard done by or whatever, go get professional advice at the time.
I just thought of some other questions.
Hit me.
Can you pass down debt? So, like, let's say there's a house with a mortgage and you're like, oh, I want my son to inherit this house, but unfortunately there's a mortgage on it. Can you do that? And if so, can the person say, I don't want the house and I don't want the mortgage?
So your debt has to be serviced before you can pass on your assets.
Okay, so you have to sell the house, pay off the debt. Yeah, okay. That's good. And what about inheritance tax comes in to New Zealand? How would that change anything for this?
Yeah.
Depends how they implement the rules, right?
Yeah.
Okay.
Yeah, we're fortunate enough to not have inheritance tax.
But you would imagine, based on other countries, that the person receiving the assets would have to pay part of it as tax.
Yeah.
And maybe have to sell those assets to do so.
Yeah.
Interesting.
I don't know. Is there talk of inheritance tax coming?
Yeah, of course, by some parties, which I'm not going to mention in this. Like,
actually, yes, I did see something.
There's going to be a 15% inheritance tax over like.
Did you actually share something about that the other day?
Yeah.
I saw that.
I did it months ago, but for some reason it keeps getting comments, and I'm just like looking at the notifications. And I don't really have the time to. Some people are like, why aren't you responding? And I'm like, I'm not.
I've moved on.
Someone from one of the parties was like, I'm from this party as a junior and would love to have a conversation to you about this. And I'm like, I don't have time. I don't care. Like, I'd rather just focus.
Yeah, that's not where my energy needs to go right now.
Okay, cool. So if people need help with a will,
yes,
where can they find you?
If you just look up Succession NZ, you will either find me on Google, on Instagram, on TikTok.
TikTok for a will.
TikTok. Do you know?
And the mortgage.
That has been my biggest lead magnet. TikTok, and everyone thinks, and I'm not trying to be ageist here at all, but that would be sort of. I think I'm old on TikTok personally, and that's not really my generation. But I've had women in their mid-50s find me on TikTok.
Yeah, my first client was like 50 from TikTok, and that was when I first started, and then I just was like 3 videos a day non-stop. Yeah. And I still do that, so I get
3 videos a day, that's impressive.
Actually, I've been doing less like this week, but it's been
that's
busy.
Yeah,
that's the goal.
Wow.
Right, so Succession NZ.
Succession
Just
NZ.
Google it. And it'll come up.
Look us up on Instagram, look us up on TikTok, or Google. If you Google Succession NZ, it'll come up. If you don't put the NZ, you're going to get the TV show. So you need the NZ.
Yeah, and so you can work remotely. So anyone in New Zealand or even overseas that needs.
Yep. So I've met clients in Australia and things like that who have done it. So the whole idea was with Succession was that it worked around people's schedules. So we have like evening appointments at night kids are in bed, you can meet us. Lunch appointments where you can both meet from your respective workplaces and actually do it in your lunch hour, not have to drive, find parking, take time off work, all those things. And weekends, but people hardly ever book a weekend, if I'm honest. Like, very, very few people ever book on the weekend.
Okay, and how long does it take? Like an hour?
Yeah, so each meeting goes for about an hour. And I think some people might panic. Like, I had somebody message me the other day and be like, that price for an hour. And I was like, oh, okay, they're probably not who I want to work with anyway. Because you before people meet with me, I email them an online form to fill out, like you will. Like, people provide you information. And that just gives me a bit of a base before I sit down with somebody. We sit down for about an hour on the screen, we go through, I do a draft and we work through it together, so I feel like people actually know what we're talking about, rather than just sitting here having a conversation and they walk away and then they get given something and they're like, what the heck does that even mean?
Some legwork beforehand.
And then we just go back and forth, because a lot of the time people don't know the answers, and then I'll have, this is how this actually works, because people don't know what they don't know. So our conversation, what I say is, this is how it's going to work practically. Here's some real life scenarios. Let's paint this picture. And they go, okay, that's changed what I initially thought in my head. And then they go away, they have a think about it, I send them a summary, and we just go back and forward until they're happy. Once they're happy, email them the final copies and they sign it with the people at the prenatal class or the cafe or their workmates.
Or the gym.
Yeah.
Yeah. Okay, cool.
Yeah.
All right, well, thank you for taking the time.
Thank you for having
to chat to me. This will be posted on Spotify, YouTube, My Free Home Buyer Academy, and probably on TikTok as well. It's the short version. All right, thanks for listening, guys.
Thank you.